As we're waiting for the rest of the attendees to file in, I'd like to just first of all wish everyone in attendance a very warm welcome to Quantum Business Law and Quantum Tax Law's Consortium on Tax Matters, and we hope that everyone enjoys this program. As we navigate through our program today, we're hoping that everyone in attendance benefits from this subject. We're always looking for subjects to speak about, and of course, today we're talking about tax incentives. Often we create tax structures. We do corporate reorganizations and estate freezes. We help to provide for the intergenerational transfer of wealth and also to protect assets of wealthy families across Canada and internationally. Today's program is going to be focused on tax in Canada, and more specifically, a section of the Income Tax Act that's very misunderstood, namely Section 248(1). Anyway, that's just a number. We're going to be talking about the federal government's program that provides incentives to companies who perform certain types of work that often is overlooked. I would suggest that there's no more misunderstood or underutilized program in Canada than the Scientific Research and Experimental Development Program. Now, with 12 o'clock being upon us, we're going to start discussing this program, and we'd encourage anyone in attendance to please feel free to ask questions as we go through. The Scientific Research and Experimental Development Program exists in a form that provides incentives to companies in Canada of all sizes to perform research and development activity. There are essentially three different types of benefits. All of them are very generous. For an example, there's tax credits, there's tax refunds, and otherwise there's benefits that companies can enjoy that would represent the refund of expenditures as high as 68% of eligible costs that have been incurred by employees. This program itself is, in my view at least, one that is not without controversy, but it doesn't make it an incredibly good program if one knows how to navigate. So we're hopeful that by the end of today's program, all in attendance will have a new understanding of a very old program and the legislation, jurisprudence, and CRA guidance documents, which are utilized by the CRA and by taxpayers who are successful in making these types of claims. The program itself is designed to foster technological development amongst companies paying tax in Canada. This includes public companies, this includes foreign-owned companies, and of course, Canadian-controlled companies. It's important to note that Canadian-controlled companies receive the biggest return insofar as they get a higher level of benefit. So I'm now sharing my screen and we're going to talk about our agenda. And as you can see in our agenda, we're talking about an introduction to scientific research, which I'll have Jordan do in a minute. But before we do that, I'd just like to make a very brief introduction. I think everyone here knows me. I'm a partner in quantum business law and quantum tax law. I'm also a founder and an affiliate firm that we have that's known as the Sheldon Group, also Sheldon and Milstein Tax Consultants. And over the last 15 years or so, I have been very much involved in working with companies who are claiming scientific research, sometimes successfully, and for companies who have not been very successful, well, our group has done much to assist, to help to bring companies to a more profitable basis for claiming scientific research tax credits. We're also going to be talking about the case law that exists, and I think you'll find that very interesting. Before we do, we'd like to talk about the legislation itself. Interestingly, this is pretty much the majority of what exists in the Income Tax Act in relation to statutory provisions for scientific research. Well, there's a little more than this. There's other statutory provisions that exist that surround this legislation, but this is the heart of the legislation. And when we look at this at first brush, you might say, well, it doesn't apply to me. But what I would encourage you to do is to think about the words. And as you're looking at that, I'll introduce my partner, Michael Miller. Michael Meller comes to us from a long career on the Bay Street firm, Dickinson Wright, Ellsworth, and a number of other major Bay Street law firms over the years, and is very heavily involved with litigation. Tax litigation has become, I would suggest, one of the most underutilized areas that taxpayers have at their disposal. So if you have a dispute with CRA and you're an accountant, as an example, you have a client in a position where you're filing an objection, why not use our firm before filing the objection? There's much that can be done. And if we're unsuccessful with the CRA, well, the Tax Court of Canada exists because taxpayers don't always agree with the CRA. I'm mentioning this in the context that there's probably no more controversial subject in tax than scientific research. So again, I'll continue to introduce Mayor Makki, who's a partner in quantum business law as well. Mayor is involved with litigating a number of Srned matters. Jeremy and Jordan are here in line. They're both associates with quantum as well. And we work collaboratively in order to provide education that's ongoing and useful information to companies who are involved in the prosecution of SR&ED. So let's talk about these words. I'm not sure if you've had a chance to look at it, but I'm hoping that you might have. So when you see what it says here, well, we're talking about some terms that are deceptively simplistic. And one of the first terms that it makes that I would like to draw your attention to is a technological advancement. This particular term in itself has caused a lot of controversy amongst the experts of what really constitutes a technological advancement. And we're going to hear directly from the former Chief Justice of the Tax Court of Canada about what his view of that is in a moment in an interview that we conducted with him some time ago. And by the way, it's very difficult for me to talk about tax or about particularly Srned, scientific research and experimental development, without talking about the former Chief Justice Bowman. I'm going to say, and if Chief Justice Bowman is watching today, I want to give him a very special welcome, and I'd like to draw attention to the fact that there's been no one in the history of our country who has done as much to create the landscape in tax as Chief Justice Bowman. And I realize he's no longer Chief Justice, but I still refer to him that way. So basically, Donald Bowman had created the law in Canada as it exists. It governs scientific research. And one of the things that you'll hear him say later on in the program is that there was a void in the legislation. This particular legislation, as brief as what it may be, speaks volumes. And there's several issues here. One of them I'll point out to you, and you'll hear verification of it later, but this technological advancement refers to advancing one's knowledge. It refers to advancing one's knowledge with respect to an area of scientific technology. Now, as you can see here, it states it's for the purposes of doing what? For the purposes of creating new or improving existing materials. Well, think about what that means. What about all of you accountants or lawyers in attendance or business owners who have clients that may be involved in improving on existing materials or devices or products? Think of the breadth that that implies. Not only does it not stop there, it goes on to talk about improving on processes. Now, I don't know how many English majors we have in attendance today, but I'd like to draw your attention to the very final part of 248(1)(c). It says, including incremental improvements thereto. You don't need to be an English major to know what incremental means. So for those of you who are interested in benefiting from this very generous government program, please stop and take note of the breadth that this legislation encompasses. It also provides an opportunity for those who are adding even incremental, very small additions to knowledge that exists. And this essentially is what drives research and development in Canada. One company will learn something and it'll be furthered by a company somewhere else. And it doesn't mean you need microscopes and lab coats. It could be that you're running a company that just works with, say, materials. Who knows what those materials could be? Could it be wood? Could it be steel? Could it be software? Could it be anything? The whole question is, does your company qualify for research and development under Section 248(1) of the Income Tax Act. It kind of causes me to stop and wonder why this isn't at the heart of what most companies are looking at. There's much in the way of false information being propagated about the eligibility criteria for scientific research. But I'm hoping that this quick glimpse at this legislation will help in order for individuals to understand the type of potential there is to make claims that you have a right in law for under Section 248(1) of the Income Tax Act. Without further ado, we'd like to move along here. We'd like to talk about some of the other issues. I'd like to call on Jordan now to give a brief explanation about scientific research and how it applies in industry. Jordan, please.
Sure. Thank you so much, Todd. And so I thought quickly before we went into greater detail, it would be good at this point just to go through some of the basics when it comes to preparing and claiming for Srned. And so to start with, Srned reimburses eligible expenses incurred in the research and development process, such as salaries, contractor invoices, as well as waste and materials and other overhead costs that are incurred in the process of research and development. And so employers can receive up to about 65% of salary as a maximum cash refund. And it can be filed up to 18 months following a company's fiscal year. Those are some basic facts on it as well. And so now the question is, who is eligible for Srned? And so as Todd had mentioned, claimants must be corporations or partnerships that are paying tax in Canada. The work must be completed within Canada, and companies really in any industry can apply for Srned, but there are some exclusions in that. Some of the common claim categories include manufacturing, plastics, information technology, artificial intelligence, engineering, but it can really be any industry that is regularly advancing their knowledge about their technology. And next, here it's changing. And so this brings us to the eligibility criteria. So there are 3 eligibility criteria that a project must satisfy in order to be eligible for the Srned program. And so the first of which is that the project or the work has to have a technological uncertainty. And so this comes in the form of an obstacle or a problem that is preventing a claimant from solving their objective or resolving their challenge. And so what makes something a technological uncertainty is that there has to be limited knowledge available to one to being able to solve that problem or overcome the obstacle. That's the difference between any problem and a technological uncertainty. And the next one is that the project has to result in a technological advancement. And so a technological advancement is very closely linked with that technological uncertainty. And so whenever you resolve or attempt to resolve your technological uncertainty, the knowledge you've gained is your technological advancement. And then the third criteria that I thought we'd go through quickly as well is that the work has to be undertaken in a systematic investigation. And so this is the procedure in which your experimentation follows, and the hypothesis, your work has to be guided by a hypothesis. You have to have a proposed solution that you expect will resolve your problem. And that has to be the guiding, the motivating factor within your experimentation.
Jordan, I was just going to stop you for a minute, if you don't mind. I'm just thinking about the words here. Well, how many companies who produce products, they make improvements on whatever may exist now, and they're very, very proud of what they've done. How often do you see companies like that looking at their product as advancements?
Yes, sir. Yeah, I mean, the term technological advancement, I mean, it's caused a lot of controversy amongst the CRA, amongst claimants. And so many people might look at a technological advancement. They might be, let's say, creating a new fixture or creating a new design for one of their products. And they ask themselves, is this a technological advancement? Well, they might think it's not the case because there's so many other companies that are doing similar work. It might be looked at as routine. And so by that standpoint, they're not really creating any new technology for their industry. They're more just sort of making small improvements to it.
But isn't the key, the advancement is your knowledge? Advancement is not a physical thing. Isn't that the key?
Absolutely.
Yeah. I think that's something that if there's one takeaway that we'd like people to understand today, is that an advancement in technology is the advancement of your general understanding about science or technology, please try to disassociate the actual product that you're developing from your advancement. Sorry, Jordan, go ahead.
Not a problem, not a problem. And so many people will ask, does my project really qualify for SR&ED? And so, as I mentioned before, you don't have to be successful in SR&ED in order for a project to qualify. Oftentimes, through unsuccessful or partially completed projects, there's really more knowledge that is gained through your failures than it is through your successes. And in addition to that, like Todd had mentioned, you have to demonstrate that you have made a technological advancement. And as he said, a technological advancement is not a material thing. It's not necessarily creating new technology or your finished product. According to case law, we have it quoted right here. It says a technological advancement occurs when you acquire knowledge that is not generally accessible to a competent professional in the field. So it's not the design, but it's rather the scientific or technological knowledge that is gained through your work. And
Yeah, if you think about that, oh, sorry, go ahead. Sorry.
No problem. The key part of that is whether or not the information you gained, whether or not it was generally accessible within your field. And so some examples of generally accessible might be, would you be able to find this information over the internet, for example, in a forum? Or would you be able to find this information through a scientific textbook? Or let's say a scientific manuscript from a university? Or another avenue could be asking a reasonably competent colleague in the field. So that could be other engineers at your company. It could be some of the contractors that you've been working with, suppliers, or just another engineer that you're familiar with. So if the information you're gaining is not available through these avenues, then it could very likely be a technological advancement. If it's not, as long as it's not generally accessible within your field.
Well, thank you, Jordan. All right, so I'm just going to pose a question to the audience and to our expert panel as well. In the case of Thomas Edison, was the advancement the light bulb? Or was it the dozens of times that he attempted to develop the light bulb unsuccessfully? Which is the advancement?
Well, I believe that there would be advancements throughout both, but certainly through the iterative process of coming up with different designs that had failed, he would gain the resultant knowledge about electronics, about electricity, and about the properties of the light bulb. That is the advancement, the underlying knowledge that he had gained through his experiments.
So when you think about conductivity, you think about electrical interference, you think about dissipation of heat, you think about whatever you folks in attendance today may worry about in your world of technology. If you're in software, it's integration, it's compression, it's security. If you're in mechanical engineering, it's working with tight tolerances, it's developing new welding techniques. I mean, if you're in woodworking, you might have a certain kind of finish. If you're in, I mean, it's endless, all right, countless, various different ways. But isn't your advancement resulting from a journey? Isn't it the journey of learning? Isn't it the iterative process that Jordan just referred to? So I believe the expression you just used is the iterative process. Is that right, Jordan? All right, now I'd like you to think about that in the context of what I might call a experimental development, which is a term which really we've already defined. And when we attempt to develop something experimentally, that becomes the basis and the groundwork. Anyway, please continue, Jordan.
Well, that's actually.
Oh, is it? Okay.
I think the next part now is Northwest Hydraulic Consultants.
Oh, okay, great. All right, so I'm going to kick it off, and then I'll turn it over to our group here. So
just before you do that, I just want to say that if you wanted anyone watching to sum up what Jordan has just said, I think it's the acquiring of knowledge that's not generally available. And that's sort of sums up what a successful SR&ED is. And I'm quoting Jordan when I say that. Sorry, Todd, go ahead.
Oh, no, that's great, Michael. I think those words are incredibly simplistic. One other way of expressing it, if you were to define SR&ED, you might say, you said acquiring knowledge, but how about if we just kind of fine tune it like that proverbial lens on a camera? The more we turn, the more the image becomes clearer. And what if we were to say that scientific research is the acquisition of knowledge that's not generally accessible to a competent professional in the field? I always think that words are important. I always think that words, since they convey meaning, it's critical to be able to nail it down, particularly if you're the head of an organization. We have many people under you or working collaboratively with you in a fashion that you need to collaborate to make claims for scientific research. And for language to be understandable, for consistent understanding, we always consider that to be important.
Yeah, sure.
We're going to go ahead, Joe. Yeah.
Yeah. So I mean, I think just as a closing point on this, anyway, when it comes to Srned for prospective claimants who are trying to decide whether or not they have Srned activity or whether or not it's something they should look into, I think the key thing is what Michael just said. And so it's really, don't really pay attention to the designs that you're coming up with or the resultant products, but pay attention more to the question in terms of whether or not you gain new knowledge that's not available, whether or not you gain new information that's not available on the internet, or if you were to ask another individual in the field.
Right. Before we springboard into the case law, which we love, by the way, I'd just like to invite our panelists if they have any other comments before we move on.
I just have one comment. If we get over the hurdle of technological uncertainty, which is 80–90% of the fight usually, once you get over that hurdle, technological uncertainty and an advancement are linked very close together. It's a lower threshold once you get over, if you do establish, for instance, in court, that you do have a technological uncertainty, it's a lot easier to establish that you have an advancement. Because like Justice Bowman said, it's infinitesimal knowledge that you have to gain, right? The biggest hurdle is the technological uncertainty part. Once you get over that, a failure or infinitesimal knowledge is easier to the threshold come by.
Good point, Matt. Just when you think about, what we've covered already in the few minutes that we've started this program, we're talking about definitions, and Mayor's bringing up this other term here, technological uncertainty. And by the way, for those of you who have been claiming for years, I suggest that you consider pushing the reset button and starting again, because we're going to give you some nuances that might not be familiar. In fact, I don't know that some of the things we've talked about are that well known at all. So let's talk for a minute about technological advancement in light of it being linked, just like what Mayor said. And I agree with you, Mayor. So Mayor's saying the two are linked. Well, how are they linked? Well, let's think about that. If you're advancing technology, you're advancing your understanding. So in other words, you're learning something. So the uncertainty sometimes is self-evident because the opposite of what you've learned is what you previously did not know. Isn't that true? In other words, the opposite of your advancement is your uncertainty. If your advancement means you've learned something about metallurgical science, you're bending steel, it's fracturing, you're dealing with brittleness, hardness, all that stuff. Well, at the end of the day, you've learned to bend steel in a more favorable way. Maybe nothing to anybody else, but to you, it was an uncertainty. To quote Chief Justice Bowman, he also said that uncertainty exists in the minds of the performer. So it's very, very important when we struggle to understand what uncertainty is. And in courts, there's been debates as to what uncertainty really is. And in audit situations, there've been debates as well. So we're here to provide that kind of clarity on some issues that may just be ignored as we kind of shoot through the process. We want to stop and look at it. So let's talk about case law, one of our favorite subjects. So I'm going to start off by saying that it was a group of engineers from Western Canada who formed a company called Northwest Hydraulics. They were in the business of studying dams and dikes, waterbeds, hydraulic system water, issues such as sedimentation, soil erosion, turbidity, the positioning of an apparatus at the bottom of the basin was placed in a certain position. Should it be 72 degrees from center? Should it be 75 degrees from center? What about all the debris that would become jammed in the apparatus as it was turning? Should use filters, meshes, screens, combinations of things, all things that may have appeared to an outsider as being purely simplistic. Well, they were using dams back in Egypt, ancient Egypt. This kind of technology may well have existed in a fairly advanced form for perhaps thousands of years. Having said that, Northwest Hydraulics put forward a claim that was denied initially by CRA, where the Tax Court of Canada decided to overturn a negative position in favor of a taxpayer. And Chief Justice Bowman, who we've worked very closely with, and of course gave me a 200-hour or close to that course in litigation. We started our litigation firm a number of years ago. I don't get much involved in litigation anymore. I'm more of a tax planner and obviously implement corporate reorganization strategies in Canada and internationally. But however, we've been involved very heavily in assisting hundreds of companies across Canada in putting forward good claims from the beginning based on Northwest Hydraulics, helping engineers and scientists to reason on what Chief Justice Bowman really meant, and then assisting to put forward claims that are being accepted by CRA. So to kick it off, I'd like to call on Michael Miller to talk to us about what you take home from Northwest Hydraulics and what should people know, Michael?
I'm going to begin by following up on what Mayor said, the infinitesimal progress. And you'll hear, I believe, later in this webinar, Justice Bowman saying that spectacular breakthroughs are rare and make up a very small part of the results of SR&ED in Canada. So it's not going to be you turn the switch and all of a sudden the light went on. It's going to be a long process, as we talked about. Some of the things that I find helpful in Northwest hydraulic consultants is, number one, almost every case before the tax court refers to it. So it has set the course of how this works, how SR&ED works in Canada. One of the things that I find interesting is that you can take a screw and you can take a nut and you can take a bolt. Each one have already been developed and created and would not be accessible for the purposes of SR&ED. However, if you find a new way to put the known together and combine them, that could very well be available for a SR&ED. So it's not, you don't have to invent everything. It's how you put it together and the knowledge you obtain by using knowledge that you gain as you go through it. It's also, what if you invent something or come across something or develop something, and you get a SR&ED grant, a SR&ED credit, and someone has done it in China as well? What does that mean for your SR&ED? So it means if we didn't know about it and it wasn't generally known what happened somewhere else in the world, your SR&ED is still valid. So you don't have to be the first one in the world ever to come up with something. But if someone else has done it and it's not generally known, then you're safe. And it's interesting, you don't have to disclose what your product is. The knowledge that you have and you gained and you get a SR&ED credit, what does that mean? Does the whole world have to know about it? And the answer is no, you don't have to share it. So it's very possible your next door neighbor could come up with the same thing, although improbable. That's an interesting part of this case as well. I also find it interesting that that SR&ED is something that so many companies can take advantage of, and so many accountants and lawyers can help their clients obtain by getting knowledge about SR&ED, and that's something that we do. And we think it's important that before you start a project, you start it knowing what you have to do, because you have to have a hypothesis of what it is you're doing, and that's got to be set out right from the beginning. So don't start on your own, start with some good advice.
Okay.
Thanks, Todd.
Oh, thank you. I'd like to call on Jeremy Louie, who has some comments that he'd like to make in reference to this whole notion of advancement and also knowledge. Jeremy, would you please help us to understand your point of view on the subject we've covered so far?
In the quote taken from this case from Chief Justice Bowman's decision on Northwest Hydraulic Consultants, there's these two paragraphs and 2 points that I'd like to make. The first is on the question of how much knowledge must you gain to qualify for SR&ED. There are a lot of misconceptions about the program. One of them being that you need to make some kind of scientific breakthrough to qualify for the program, and that's simply not true. Justice Bowman actually addresses that directly in the second quote there, where it says scientific research involves gradual, indeed infinitesimal progress. If you think about what the word infinitesimal means, it's a term taken from mathematics, and it means more than 0 and less than 1. So he was really trying to make the point that you might only gain a very, very small amount of knowledge, and that's all that's required to have a technological advancement as far as the law is concerned. That quote continues, and it says that scientific breakthroughs are rare and make up a very small part of the results of Srned in Canada. So that's one myth that if we could accomplish dispelling that myth today, I think that would be a great success.
Yeah, Jeremy, can you give us an example of how an incremental advancement can take place for an existing product or process? Like, give us some kind of idea that we can sink our teeth into and understand.
Sure. We at the Sheldon Group, I'm a partner at Sheldon Group, and we do hundreds of claims every year in just about every industry in Canada. We have claims in different industries that have been going on year after year on the same product. But what they're doing is they're slowly, incrementally improving that product year after year, encountering different challenges over the years, but they're not creating some kind of breakthrough each time. It can be one continuous project for 10 years, and every year they're learning something that's not generally accessible to them. So it doesn't have to be a brand new product, doesn't need to be a scientific breakthrough. It simply needs to be that incremental, that infinitesimal progress that Justice Bowman was talking about in this case.
Okay, let's dig a little deeper. Let's move on to our part. Do we have a part 2, gentlemen? Okay, here we go. Michael, I'd like you to elaborate a bit more. As a litigator, I believe you have over 40 years of experience in litigation. I'd like you to give us some idea on how you would deal with a challenge where a company has an understanding, have increased their understanding, and how, where as an example, this was called into challenge. What kinds of questions should we be asking ourselves? Should we be asking ourselves about where the learning comes from? Should it involve experimentation? Should it involve iterations? How would you see an advancement of technology taking place?
Well, if you're talking about in the court system, is that what you're talking about, Todd? Yeah. So then you get a SR&ED when you file your tax return. You're advising the CRA that you want a credit. They look at it, they study it. They've got 5 criteria, 4 fundamental, and the 5th is one that they have added. And they all come from, as it happens, they all come from the case that we've been talking about. The 4 examples, the 4 requirements are technical risks. So you haven't seen this happen, so you don't know it's going to work, whatever your vision is. And if it is what's called routine engineering, which is something that standard procedure or routinely in engineering, that's not going to qualify. It has to be something that there's a risk to what you're doing because it doesn't exist. You then have to form a hypothesis, which is specifically aimed at what you're trying to do. So it's whether you're trying to reduce or eliminate technology or uncertainty, or you're trying to increase it. It must not be routine, and the hypothesis has to be set out. So at the end, you can prove whether you were able to successful or not successful. And then there's trained and systematic observation, and that would be how the it's the discipline of the scientific method and the hypothesis. So it's got to be clearly set out. A CRA is going to want to see what you did, what were you shooting for, was it trial or error? And the fourth is technical advancement. At the end of it, what did you achieve from what you did? And I think as Jordan said earlier, that you don't have to be successful. You don't have to come up with the right answer. You just have to have tried. And so those are the things that CRA is looking for. And a lot of it, it's submitted to CRA with a lot of technical information. You're going to have to decide who your experts are going to be to justify what you're doing and to record what you've been doing. CRA wants to be satisfied that what you're claiming and the costs that you're claiming and the advancement that you're claiming are all set out and can be proven.
Very good. Thank you, Mike.
Yeah.
Oh, sorry about that. I'd like to call on Mayor Makki to make a comment here about this term. There's a term that Chief Justice Bowman, as he was then called, had referred to, one that divides the experts more than any other. Mayor, maybe you could comment on why that is. What is it about routine engineering that throws the whole world off as far as understanding it and how to apply it? Please help us understand.
I think always the biggest fights in courts and before you get into litigation is always over this one issue. And you will have to, in my opinion, hire an expert to help give his impartial testimony on the subject, because you have to first establish you have a technological uncertainty. Then you have to establish what are the routine techniques used in the industry. Then you have to establish with expert testimony why yours was not routine. So the biggest fight usually is whether something was standard and routine and versus why your project was not.
Very
So in
good.
my opinion, that's the biggest fight always. And it's always imperative that you hire an expert to attest to that.
Yeah. Now, I'd like to,
Can I just add, Todd, that in the recent case A&D Precision, the main witness, who was not an expert as an expert would be thought of in the way Mayor is talking about, is the founder of the company. He's a fellow that came to Canada numerous years ago, started off in the machine shop where he worked for 4 or 5 years, and then opened up his own company, A&D Precision. And he developed all these wonderful things. And for Srned purposes, the court, Justice Russell, looked at it and recognized this man who had no education, no formal education, as in essence an expert. He gave evidence at his trial, and the court accepted it. And so, yes, you do. I agree completely with Mayor. You do need experts, but you don't always have to be someone with a PhD to be an expert.
One more thing I wanted to add also on top of what Michael just said. Remember, this is a lot of the terms in SR&ED are semantics. So routine engineering, let's break that down. If it's something standard, if you're discovering, let's say, what we always say here, discovering cancer, you're gonna use a microscope, right? But by the definition, using a microscope, that's a standard procedure to look through a microscope to develop something new. That's going to be routine. That's going to be argued against your case always. You have to find a way to educate your audience on why that there will always be routine segments within your case and why yours doesn't fit that.
okay, I'd like to call on Jeremy just for a minute to kind of hear from his point of view, dealing with a lot of individuals who have claimed SR&ED over the years. How would you see the application of routine engineering being misunderstood, and how can it be better understood, Jeremy?
Thanks, Todd. In terms of the term routine engineering being misunderstood, we have heard from CRA many times, both in the cases that we have helped to prepare at Sheldon Group and the cases that we've defended and litigated for in quantum business law. We've heard CRA take the stance that all you did was routine engineering. And because you use known techniques, you've used known procedures that are well established, because you use those techniques and procedures, all you did was routine engineering. None of what you did was eligible. That's what we've heard from CRA. Maybe I'd ask you, Todd, when you hear CRA tell that to a taxpayer, or you hear that in one of our cases, how would you respond to that assertion?
Well, I would say the following, that routine engineering is not work that engineers do routinely, as the term may imply. Quite the opposite. I would suggest that routine engineering is best, if this is really the best definition. This is the man who created the law in Canada. Chief Justice Bowman, as he was then called, had defined it. And again, I'll go back to what his preface, when he started off by saying that it's the term that appears to have divided the experts more than any other. And this is why. So he says, briefly, it describes techniques, procedures, and data. Well, it may well be that the gentleman who performs scientific research in AD engineering or AD consulting, who Michael referred to, it may be that he used known techniques, and it might be the procedures he used were also known, but the data was not known. What is data? Data is knowledge. Data is information. I would encourage our audience to look at this term, routine engineering, as a three-legged stool. Techniques, procedures, and data. And what happens to a three-legged stool if one of the legs is missing? Well, it wouldn't stand, would it? And neither would a definition that belittles qualified scientific research work as routine engineering if the data is missing, the knowledge. Probably the techniques and procedures are correct. And same can be true as in Mahyar's example, where you have a scientist appearing through the lens of a microscope. He's adding proteins, or he's altering chromosomes, or whatever he's doing. Whatever he's doing was in this book that he was trained to do. But he didn't know the interaction between the various different cells. He was unclear about things. The things that he learned were incremental. They were small advances in his understanding. By the way, we want to say this, that please don't misunderstand the fact that we have a law firm talking about litigation here as this being a litigious area. Generally speaking, most of the claims that our affiliate firm presents are accepted by CRA. There are exceptions. Why? And that is because CRA does not always agree with taxpayers. And for that reason, well, it's important that you can do something about it. And that's why the Tax Court of Canada exists, because it's a neutral forum where companies who are performing scientific research, who someone comes in and says, it's only routine engineering. Well, I'm sorry, but it's not, because the data was not available. The knowledge was not available. The knowledge is the advancement. The acquisition of that knowledge is what gives rise to the resolution of a technological uncertainty. So as Mahyar said, the resolution of a technological uncertainty is inextricably linked to an advancement in the technology. The two become one. So this is very, very important to understand. So please, those of you who are not involved in the highest level of technology, those of you who are working with steel, working with wood, developing software, doing other things that may, because of being humble, you may not recognize that you're eligible. Well, this, I think, is a call to action here to say, well, maybe you're qualified for hundreds of thousands of dollars and perhaps millions of dollars that you may otherwise have missed out on.
Maybe this might be a good time to see some of the things that Justice Bowman himself has to say.
Yeah, please do. Yeah, Jeremy, let's hear this. Yeah.
So just to give some background on what we're about to show you, a couple of years ago, as you can see in this picture, Todd had the great opportunity of interviewing the former Chief Justice Donald Bowman on this very topic, on SR&ED, and we were able to ask him some very pertinent questions. And without further ado, I'll show a couple of clips from the interview, and maybe we can get some of the expert panel's comments on them afterwards. Todd, can you stop sharing your screen, please? Thank you.
Justice Bowman, I wanted to ask you about the issue of contemporaneous documentation. Do you believe that at the audit level, do you believe that contemporaneous documentation should be the basis for determining eligibility, or do you believe that the requirement for documentation should only be evidentiary only? In other words, should be purely to support that the activity took place?
It should be primarily evidentiary, but I'm not saying that that a claim for Centric research tax credit should be excluded if there is no contemporary documentation. There should be. Depends on whether or not the researcher is believed.
You are aware that, and I know that you are, the 5 questions that CRA arms RTAs with, they've taken your 5 questions from Northwest Hydraulics, and they've made a slight revision to one of them to say that there's a record of the hypothesis kept as the work takes place, which really has put RTAs in a position where, you know, they're now, at least in many cases, basing the decision on whether the work is eligible or not on the documentation, rather than looking at the documentation as being evidentiary only.
Well, I would say that the documentation is the strongest evidence that you have in many cases. So I have it, but I'm not saying it's essential evidence. I would reject scientific research claims just because there is no documentation. Depends on whether you believe the tax credit.
Thank you, Jeremy. So just thinking about this for a minute, and over the years in working with the Honorable Donald G.H. Bowman, one of the things that stands out in my mind that he always tried to impress, and that was, you know, how valuable documentation is. And, you know, one of the things he said to me that, you know, Todd, he says, judges are no different than auditors. And that is, if they don't believe something, or if they're not sure, well, the easiest thing to do is say no. So I think that documentation is important from the point of view that it helps to corroborate or verify that something happened. But what's your takeaway on this, gentlemen? I'll open this up to the panel.
So
I'll speak at the same time.
do you want me? Let me
Go ahead.
jump in quickly. So
Please.
nowhere in the act states that you need documentation. Having said that, and whether it's Srned or anything else, whether you're in audit, you want to provide evidence, right? And it's helpful to have that evidence. I think Justice in A6 EHR 2015 tax court case said it well. If I'm going to quote her, while it will always be preferable that an appellant maintains documents to support its investigation, the act contains no requirement. This is not to say that a taxpayer should ignore detailed record keeping. Such evidence is always to be preferred, and each case will vary in respect to how evidence will be viewed. So nowhere in the act states that you need it, but it's very important. When you look at it, if you have done a scientific experiment and you have uncertainty and you've gone through the process of gaining advancement, you would think that you would keep records of it. So it's important to maintain records of it in case you go through an audit, in case you need to go through litigation.
Yeah, so I think that the key is it should be evidentiary. In other words, it should be used in order to verify that the work took place. The determination for eligibility should not be made based on the documentation. It should be based on the activity, and the documentation should be used to corroborate that actually took place. What about reconstruction of evidence? What about where a document doesn't exist and you say, well, I'm going to create a summary and state that it's been reconstructed? What is your view, Michael, of open reconstruction?
Not acceptable. It has to be done at the time that the experiment or the work is being done. They won't accept something a year and a half later that you sat down and worked out what you wanted it to say rather than what actually was happening.
So you want to be proactive in making good documentation. It may be as simple as having an email address called srned@abcco.com, where you'll email yourself things on a contemporaneous basis. So this is what we're talking about, is contemporaneous documentation, documentation that's created as the work progresses, which is the very best form of evidence. Even there is case law to support that oral testimony can be used, and it can be used to adduce eligibility as to whether or not work took place or not. And credibility of the client can also be considered, or of a taxpayer, not only by CRA, but by the courts themselves. But we're not suggesting that documentation isn't important. Any more comments from the expert panel before we move on to the next video?
I just want to say, if you're giving oral evidence 2 years later and you haven't made notes contemporaneously, how good is your evidence going to be?
Yeah.
When you're cross-examined, which you would be if you were in trial, how good is your memory going to be? How much detail are you going to have if you had no notes? So it would be inadvisable.
One other comment is there's always naturally occurring documents that takes place, what I would call empirical evidence. As an example, there might be material purchased. There's an invoice from the company that you bought it from that demonstrates that it actually was consumed. And it may be that there was emails internally back and forth, or it may be that there was a drawing, and it may be that iterations can be demonstrated by a series of drawings. Please don't dismiss the notion of applying for scientific research because you don't have good documents, because the naturally occurring documents may be enough. Jeremy, let's see the next clip, please.
Justice Bowman, CRA has taken the position that trial and error is not eligible for SR&ED. Is this semantics, or what do you think about this position?
Well, I think that's baloney. I don't believe it at all. I think that trial and error is one aspect of the technical research that goes into scientific research.
I think what they're attempting to say, and of course, I think what CRA has done is they've taken the term trial and error and they've created their own rendition, their own definition.
I don't have any doubt, for example, that Thomas Edison gets a lot of trial and error.
Undoubtedly. Good analogy. I would suggest that what they're really saying is there's no hypothesis that guided the work. But the term trial and error, and of course in Joel Theatrical, Justice Somerville had mentioned the same subject and said that he didn't know about any jurisprudence that stated clearly that trial and error wasn't eligible. So again, I think,
No, I agree with you.
would you say there should be more training in this area for CRA officials?
They shouldn't need training, for goodness sake. They should be able to reach that conclusion on their own.
Thank you. Jeremy, what's your definition? How do you take that? How do you look at CRA's view of trial and error, and what does it really mean in the real world?
Well,
Just before he answers, can I ask, what does the word baloney mean?
Metaphorical, Michael, entirely. I assure you that the Honorable Donald G.H. Bowman does not indulge.
Sorry, Jeff.
No, it's a good point, Michael. And I couldn't say it any better than the Chief Justice himself, who said it's baloney. Again, Thomas Edison, he couldn't have invented the light bulb without trial and error. If you think about any type of research or experiments that are done in Canada, it is semantics. And it's a stance that we've seen CRA take time after time. We've heard auditors say that trial and error is not eligible. If you do trial and error, you're not doing SR&ED. Again, this is a semantics issue. The idea in my mind when CRA says that is that you're doing something random. You have no hypothesis, you have no systematic investigation. You are trying to, you're hitting things randomly, you're trying every possible option to see what sticks, and you don't have any scientific understanding beneath that. I would just say that if you're a scientist or an engineer, you might use the word trial and error to describe your experiments. And our position is it's an issue of semantics, and I don't think taxpayers should be afraid of claiming when they hear trial and error, because we don't agree with CRA's interpretation of the phrase trial and error.
Thank you, Jeremy. Let's get a brief comment from the rest of the panel. Jordan, you want to give us your comment on trial and error and how it applies, how it doesn't?
Sure, certainly. Yeah, I mean, the term trial and error, it's another misnomer or buzzword that the CRA will often use, because in reality, all experimentation, all projects, all work done by any sort of research and development company could be defined as trial and error, because all that trial and error really refers to is changing of one trial and error and iteration based on the result of the experiment. But like Jeremy said, the important part is that you have to have a hypothesis for each step of your experiment. You have to have an expectation or a proposed solution as to the results of your experiment. That's the important part. And you're not just sort of blindly throwing darts, just sort of trying random solutions without any idea whatsoever as to if they'll work or why they'll work. Most important thing is that you're doing it by the scientific method.
Thank you, Jordan. Mayor, what do you think about trial and error? Tell us how people should look at it, understand it, and apply it. Oh, you're muted, Mayor. You're muted.
Sorry about that. I don't have everyone said great things about it. The way I look at it is, if let's say you're using drills, you're just picking up a drill and you're trying different pieces randomly, right? That would be trial and error. Whereas if you have an idea or a hypothesis that you're going to weld something to create a proper measurement to stick in, those are two different things. Having said that, this is another issue with semantics and SR&ED, and there's a lot of semantics in SR&ED. And I think the importance of hiring experts early on when you're filing your SR&ED claim is really important, because while you're filing your claim, using the wrong words in your claim really affects the outcome, even though you may have SR&ED, right? So, and this is one of those.
I think what CRA is intending to say when they use the term trial and error, correctly or incorrectly, is they're saying there's no hypothesis. You're flying by the seat of your pants. Jordan used an expression, or Jeremy, I can't remember who, that you're throwing darts blindfolded. Well, that's essentially what it means. I have this round peg. I'm going to try to squeeze it into this hole. I'm not sure why it doesn't work. I don't understand the science or the physics or anything. And therefore, I'll keep doing the same thing. Let's move on. Sorry, we're running out of time. So we want to finish up. Is there any more clips, Jeremy?
We're approaching the end of the hour, and we don't want to go over it. We have a couple more slides that we'd like to go through, and then we can get into questions and answers at 1 o'clock, if that's okay, Todd.
Sure. Please proceed.
So what we're trying to hammer home with all of these things that we're saying is, it's very important how you put together your SR&ED claim. We like to say, prepare your SR&ED claim as if you are going to court. So that means keeping documentation. That's the evidence that you really did what you say that you did. We also say use legal arguments based on the Income Tax Act, based on the case law that we talked about today, the definition of technological advancements, the definition of routine engineering. Those are all very important things. The definitions in 248(1)(c) of the ITA, those are all very important components that you should be working in to your SR&ED submission and your technical write-ups. If you just write what you did and submit it without an understanding of the underlying law, you shouldn't expect a successful result necessarily. It's based on the law, and your submission should be based on the law as well. One point that we'd like to share with everyone today who's claiming SR&ED or thinking about claiming SR&ED, or maybe you've been claiming SR&ED for many years or preparing SR&ED claims for many years. We have been working in the industry for a long time, and we've noticed that most companies who are currently claiming SR&ED make this very similar mistake that we see time and time again. It's claiming SR&ED on a per project basis. We call it a more project-centric approach. Let's say you have 10 projects in the year. 2 of your projects took half the year, and the other 8 projects were small ones. Maybe they only took a couple weeks each. when I'm talking to a client and I ask who's been claiming for many years, and I ask them, which ones would you claim? Oftentimes I hear, I'll claim the first 2 projects because those are the bulk of the work. The other ones are too small. It's too much work to write 8 more projects. So we'll take the 2 and we'll leave the 8 behind. Maybe in some cases there's 100 projects. And are you going to write 100 different SR&ED projects and submit that? And I don't think that there's very few companies in Canada who would put the time into writing 100 projects. So we're seeing companies leaving money on the table because they're leaving behind the small, the numerous, the, let's say, less complex projects, because on their own, they don't stand up and they aren't worth writing. What we've developed at Sheldon Group is a way to claim all eligible activities that happen throughout the year. Even if you have 100 projects, even if you have 1,000 projects, we're able to capture virtually all of the eligible activity that your company is doing. The reason is because those smaller projects, you may have a technological uncertainty, but on their own, they might not have enough complexity. If you have 100 projects with the same underlying technical or technological problem, there are ways to combine them together and reduce the number of projects that you're submitting. We have a very thorough system of doing this in documentation and so forth, be able to capture these projects and submit them. And we're finding that we can increase the claim size by 50%, 100%, some cases even more, by using our proprietary learning centric approach. We're now at 1 o'clock, and before we open up to questions, we'd like to share the fact that we are hosting another webinar by Quantum Business Law on the basics of trusts. It's on Thursday, March the 25th. It's going to be at the same time, 12 p.m. Eastern Daylight Time. And everyone here is invited to attend that session as well. That concludes our presentation. And at this time, we would like to open up the floor for questions from the audience for our expert panel.
Yeah, and as we start to look at the questions, and maybe Jeremy will start to table them, I'll just leave this, expand this message to include all tax issues. If there are tax disputes of any sort, our law firm Quantum Tax Law is very happy to assist in dealing with these matters. And oftentimes things only go as far as an objection. So whether you have a SR&ED claim that's been denied, please don't give up. If you've been assessed for other tax reasons, then we're delighted to help out. If there's a need to prepare SR&ED claims, well, our folks here in our affiliate firm in Sheldon are industry leaders in this way. I'd like to thank everyone very much for attending, and I know that many of you are return visitors and loyal supporters of our group, and we really appreciate that. Jeremy, why don't we start tabling some of the questions?
Sure. We answered this question. Oh, there's some open questions here. Well, this question we answered, but maybe it's a good question. And the question is, how do you establish what's not generally available?
Yeah, interesting question. I'm going to say that if you were to Google and see if the answer is there, it's not a bad starting point. In your industry, there may be chat rooms, particularly in software. There's various different chat rooms, and other industries have similar kinds of tools where information is shared. Try to envision you're speaking to 100 peers and look at the reactions on their faces. Are they saying, oh, this is boring, I've heard all this before? Or are they saying, wow, that's kind of interesting, or it's absolutely fascinating? There's no actual measure for that. It's quite subjective. But the question is that knowledge available on the public domain? And that's a fairly reasonable test.
So going online, maybe what's published in textbooks, and what is a reasonably competent professional, what are they expected to know with the generally available body of knowledge in that industry?
Sure, and I just had a comment on that as well. You were mentioning in the question that information must have been shared on that issue, but the important part to pay attention to is, though, as well, is that even if there is some information available on that topic, so long as you are gaining some incremental knowledge in addition to what's already been established. That is eligible activity as well. And going back to the definition that Justice Bowman had used some of his terms, infinitesimal is also a key term for the subject. So there may be a large amount of information about a certain topic, could be information technology, for example. But so long as you're gaining a very small amount of knowledge in addition to what's already been gained, then it's perfectly eligible activity.
Yeah, now I'm noticing some interesting questions. One of them deals with, the question is, isn't this really the scientific method? And yes, it is. Essentially, it means many things to many people. You think of a high school science project, you have a hypothesis or theory you're seeking to confirm or modify. So our member of our audience who posed that question, I believe, hit the nail on the head. We have another question here talking about an individual who's doing some software development, perhaps for a website. And one of the questions is he really still isn't sure about the submission. Is a write-up done? And who can speak to a software developer? Well, our team has all of that skill. They've done more than hundreds of these types of claims in software. And no matter what technology is, our team has experienced in practically every sort of technology that exists. So all of that writing is done by individuals who are trained in income tax law, who have an understanding of the jurisprudence, have an understanding of what it takes to make it successful. And I think with that note, I think we'll close off our program, and we're very much looking forward to seeing all of you back in a short time.
There's one more question, though, actually.
Oh, please.
Yeah, so Ash asked a question. What if it's solved by a competitor, but not shared, but the solution was not shared in the public? And so what I'd say to that question was that although the problem was solved, the actual resolution to that problem, if it was not shared in the public, then it wouldn't be generally accessible information. And so if you were to still gain that information through your work, then it can be constituted as a technological advancement and it's eligible work.
Right. There's another question. Thank you very much, Jordan, about where does serendipity fit in? We talked about trial and error, but serendipity, if you happen to come across the answer by good luck, is that qualified for SR&ED? We're not going to say that it does not. It really, the question is really, was there a technological advancement? Did you learn something that's not generally accessible? And did you have a systematic investigation? Meaning, did you have a hypothesis before you did your experiment that guided your work? If you did not have a hypothesis and you simply stumbled across the answer to your question, then probably you didn't have any SR&ED. But if you did that, if you did have a hypothesis and you knew what you were doing, maybe you came across something unexpected, that's okay. We just have to be able to demonstrate that you had the systematic investigation and that you really had a hypothesis that was guiding your work throughout the process.
Very good. So I'd like to thank everyone in attendance, and we look forward to seeing you. What is the next date for our next program, and what is the theme, Jeremy?
The next program is, again, it's the basics of trusts. It's hosted by Quantum Business Law, and it's going to be next Thursday, two Thursdays from now, March the 25th.
Yeah, we find there's a lot of mystery surrounded by trusts, and we're going to unshroud the mystery and help accountants and lawyers and business people to understand how trusts can be used effectively in estate planning and provision of transferring assets to the next generation tax effectively. And thank you very much. And we look forward to seeing everybody again on March 25th.
Bye, everyone.
Bye-bye.
Bye.